In light of the James Freeman case, there are a lot of people who are mistakenly under the impression that there is a First Amendment right to film in a courtroom. And I am going to go over this, hopefully to put this to bed, that the logic that they're using to come to the conclusion there's a First Amendment right to film in a courtroom is broken. The First Amendment of the U.S. Constitution is a great place to start, and it reads, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people peaceably to assemble, and to petition the government for a redress of grievances. Nowhere in there does it say that you have a right to film or photograph anything. Why do you think that the First Amendment applies to photography and filming? Well, this is Marbury versus Madison. It's a seminal U.S. Supreme Court case. Obviously has nothing to do with filming. It held two very important things. First thing is that the Constitution is the supreme law of the land and that Congress can't pass statutes that abridge it. So, the second thing it held is it is emphatically the province and duty of the Judicial Department to say what the law is. Those who apply the rule to particular cases must, of necessity, expound and interpret that rule. If two laws conflict with each other, the courts must decide on the operation of each. So the Supreme Court made determinations that the First Amendment applied to photography. It applied to recordings in general. It applied to art. So that's why we know that the First Amendment applies to photography. But does it apply to filming in courts? And the answer to that, this is Rice v. Kempker. I've gone over it recently. Just had a really good, a really well-written statement. So that's why I'm reading out of this one instead of going to the individual cases. But in this one, it reads, we find no need to engage in the two-part inquiry, instead address the issue directly and hold that the First Amendment does not protect the use of video cameras or any other cameras, or for that matter, audio recorders in the execution chamber. Because we hold that neither the public nor the media has a First Amendment right to videotape, photograph, or make audio recordings of government proceedings that are by law open to the public, we find it unnecessary to decide whether executions must be open to the public. While Richmond mandates that criminal trials be open to the public, no court has ruled that videotaping or cameras are required to satisfy this right of access. Instead, courts have universally found that restrictions on videotaping and cameras do not implicate the First Amendment guarantee of public access. See Whiteland Woods v. Township of West Whiteland, holding the public has no right to videotape planning commission meetings that were required to be public. U.S. v. Curley, holding that the public has no right to videotape trial even when the defendant wishes it to be videotaped. Westmoreland v. Columbia Broadcasting System. There is a long leap, however, between a public right under the First Amendment to attend trials and a public right under the First Amendment to see a given trial televised. U.S. v. Hastings, holding that the press had no right to videotape criminal trials. Nixon v. Warner Communications. This is a U.S. Supreme Court case holding that no First Amendment right existed to publish or copy exhibits displayed in court. U.S. v. Macdougall, holding that the First Amendment right of access does not extend to videotape deposition testimony of then-President Clinton. As the Second Circuit has observed, the First Amendment right of access is limited to physical presence at trials. U.S. v. Yonkers Board of Education. Based on the overwhelming weight of existing authority as well as our general understanding of First Amendment principles, we hold that the media policy banning the use of video cameras and other cameras in the execution chamber does not burden any of New Life's First Amendment rights. From there we go to Estes V Texas. This is a Supreme Court case from '65 where they televised this guy's trial. It is said, however, that the freedoms guaranteed in the First Amendment extend a right to the news media to televise from the courtroom, and that to refuse to honor this privilege is to discriminate between the newspapers and television. This is a misconception of the rights of the press. The free press has been a mighty catalyst in awakening public interest in governmental affairs, exposing corruption among public officers and employees, and generally informing the citizenry of public events and occurrences, including court proceedings. While maximum freedom must be allowed the press in carrying on this important function in a democratic society, its exercise must necessarily be subject to the maintenance of absolute fairness in the judicial process. While the state and federal courts have differed over what spectators may be excluded from a criminal trial, the amicus curiae brief of the National Association of Broadcasters and the Radio Television News Directors Association says, as indeed it must, that neither of these two amendments, first and sixth, speaks of an unlimited right of access to the courtroom on the part of broadcasting media. Moreover, they recognize that the primary concern of all must be the proper administration of justice, that the life or liberty of any individual in this land should not be put in jeopardy because of actions of any news media, and that the due process requirements both in the Fifth and 14th Amendments and the provisions of the Sixth Amendment require a procedure that will assure a fair trial. So in Estes V Texas, they ended up holding that they couldn't film broadcast TV in the courtroom because it denied the Fifth and 14th Amendment rights of the defendant. Well, they narrowed that a bit in Chandler v. Florida. In Chandler v. Florida, the Florida promulgated rules that allowed broadcast television people to record in their courts under very limited circumstances. And because they limited the methods by which they were able to televise, then the court allowed them, the U.S. Supreme Court said that that didn't violate the due process. So these are the rules that Florida implemented. For example, no more than one television camera and only one camera technician are allowed. Existing recording system used by court reporters are used by broadcasters for audio pickup. So there's still only the court's recording system that's being used for audio pickup, not a separate one. Where more than one broadcast news organization seeks to cover a trial, the media must pool coverage. No artificial lighting is allowed. The equipment is positioned in a fixed location and it may not be moved during trial. Videotaping equipment must be remote from the courtroom. Film, videotape, and lenses may not be changed while court is in session. No audio recording of conferences between lawyers, parties, and counsel or at the bench is permitted. The judge has sole and plenary, that means it's not subject to review. The judge has sole and plenary discretion to exclude coverage of certain witnesses, and the jury may not be filmed. The judge has discretionary power to forbid coverage whenever satisfied that the coverage may have a deleterious effect on the paramount right of the defendant to a fair trial. The Florida Supreme Court has the right to revise these rules as experience dictates, or indeed to bar all broadcast coverage of photography in courtrooms. So because they limited it quite a bit, the U.S. Supreme Court allowed it. They didn't have an issue with it. Some choice bits out of the holding, though, is while we've concluded that due process clause does not prohibit electronic media coverage of judicial proceedings per se, by the same token, we reject the argument that the First and Sixth Amendments of the United States Constitution mandate entry of electronic media into judicial proceedings. So the Florida Supreme Court thought that due process didn't entirely prohibit electronic media coverage, but also that the First and Sixth Amendments don't mandate electronic media coverage. The Florida court relied on the U.S. Supreme Court holding in Nixon v. Warner. We mentioned that one in Rice v. Kemper. In the first place, there's no constitutional right to have live witness testimony recorded and broadcast. Second, while the guarantee of public trial, in the words of Mr. Justice Black, is a safeguard against any attempt to employ our courts as instruments of persecution, it confers no special benefit on the press, nor does the Sixth Amendment require that the trial, or any part of it, be broadcast live or on tape to the public. The requirement of a public trial is satisfied by the opportunity of members of the press, or of the public and the press, to attend the trial and report on what they have observed. So no court has held that you have a right to film in a courtroom. And now we talked about how the U.S. Supreme Court is the ultimate arbiter on what is or isn't constitutional. And they're the ones who determine that photography is covered by the First Amendment, but they are also excluding photography from their courtroom. This is the SupremeCourt.gov. This is their courtroom seating for oral arguments. You will go through a security checkpoint as you enter the building and again as you enter the courtroom. Weapons or other dangerous or illegal items are not allowed on the grounds or in the building. Visitors may not take any electronic devices into the courtroom when the court is in session. Cameras, cell phones, tablets, pagers, recorders, or similar items. Visitors may also not take in hats, overcoats, magazines, books, briefcases, or luggage, sunglasses, identification tags other than military, display buttons, and inappropriate clothing may not be worn, etc., etc., etc. So the Supreme Court, the ultimate arbiter on what is or isn't constitutional, in the US, the Supreme Court is it. You know, you are not it. The Supreme Court is it. They don't allow photography or any recording in their courtroom. So, yeah, your argument is null, and there is no First Amendment right to record in a courtroom. You may disagree with that, and I value your opinion, and you're more than welcome to have your opinion. There are Supreme Court rulings that I disagree with, but that doesn't mean that those rulings aren't valid. The state of the law is what it is. The only way you're ever going to change it is to get arrested and push it all the way up to the Supreme Court and hope they change their mind. But I wouldn't bet on it, considering that when your lawyer makes his oral argument at the Supreme Court advocating for allowing electronic devices in court, there won't be any electronic devices there. And I don't see the Supreme Court changing that anytime soon. But thank you very much for listening. Stay safe out there and happy auditing.